Good afternoon, everyone. We're just going to wait another minute or so for any additional participants to join us. All right, good afternoon, everyone. My name is Andrew Boughrum. I'm an attorney at J&G Law, formerly Jacobowitz and Gubitz. I'm going to be sharing a presentation today related to a motor vehicle personal injury case. And you could follow along with the slideshow. So about J&G, as I mentioned, we were formerly Jacobowitz and Gubitz. We've been in business since 1968. We have approximately 20 attorneys and practice in some 30 different areas of law. We have offices in Walden and Monticello, New York. And we are here for you for all of your legal needs. Now, this presentation is going to follow along with a blog series that is available on our website, jglaw.law. And it will track the various different parts of the blog series related to the personal injury case. So as an initial place to start, when you get into a motor vehicle accident, you might be left with a number of questions about who you contact, what to do, where to go, when you should act, and why you should contact an attorney. And I guess the most obvious place to start is that contacting the attorney. An attorney is someone who can help you answer each of these questions, what to do, where to go, and when to act. So it's important that you reach out to an attorney as soon as you are able to, so that we can talk about what has happened, what we need to do to prepare to present a successful personal injury case. And we can talk to you about details such as how to gather information about liability, how to start treating with medical providers, what to do to help establish a consistent and regular course of treatment so that you can make out your case for injury and for damages. So let's say that you have a motor vehicle accident. The first thing that you're going to want to do is you're going to want to make sure that everyone is okay. Take a moment to assess yourself. How are you feeling? Do you feel that you've been injured? Ask about any passengers that you may have in your vehicle. If you or any of them are feeling that you've suffered an injury, it's important to call 911 and request that an ambulance be sent to the scene. You should also ask for the police to be sent to the scene so that a police accident report can be created. If you are feeling okay and it is safe to do so, you might step outside of your vehicle to check on the other drivers that were in the accident. You might also want to use this time to take photographs of any damage that you observe to your vehicle or to any of the other vehicles in the accident. I would also recommend taking a photograph of the entire accident that captures the location of each of the vehicles in their original location. I would recommend not moving the vehicles until directed to do so by a police officer, unless it would be unsafe for you and the other vehicles to remain in their current position. So once the accident has occurred and you've assessed whether you and your passengers and the other drivers are okay, and the police are on their way, it's important to see if there have been any other motorists who have stopped to assist. If they're there, it would be important to know whether they observed what happened in the accident. If they have observed what happened in the accident, it would be worth noting whether they'd be willing to speak to the police and give a statement about what they saw and observed. All this is information gathering that's going to be useful in establishing one of the most important components of a personal injury case, the liability. So your statements to the police, the statements of any witnesses, and the statements given by the other drivers will often be recorded in a police accident report. So it's important that you give a clear and concise statement about what happened and obtain as many supporting statements from bystanders and other drivers and passengers so that the facts and circumstances don't get lost as time passes and memories fade. The photographs are also useful in helping with the liability stage because it will be a pictorial representation of what happened. You know, the expression is a picture is worth 1,000 words. Well, that applies to personal injury accident cases. The next thing that is going to be important to do at the scene of the accident is to be assessed by either an EMT who's on site or to go to a doctor's office or an emergency department to be evaluated as soon after the accident as is possible. Oftentimes in motor vehicle accident cases, people have a lot of adrenaline running through them. They've just been in an accident. They may not be fully aware of any of the injuries that they've suffered. And it's important to have a medical professional who's trained to look for signs and symptoms of injuries, do an evaluation. Another reason that doing an evaluation for injury immediately after the accident is important is because of what's called a gap in time defense. Seasoned defense attorneys will often point to a gap between the accident happening and the date of the first treatment as a defense to a personal injury accident, because they will say that if your injuries were not severe, then you wouldn't need to seek treatment. And that's why you didn't go for treatment for the first, week or a couple of days or even months. So it's important not to use the wait and see approach to your pain to see if the pain gets better, but to go have it checked out right away. The next thing that's important to do with your medical treatment is to follow up with your primary care doctor after you've been to the emergency care department. From there, your primary care doctor can help you find specialists who are going to be knowledgeable and able to help you treat and rehabilitate the injuries that you do have. The primary care can send you to people like orthopedists and neurologists and neurosurgeons, depending on the types of injuries that you have. Those specialists can also help you order diagnostic tests such as MRIs, CAT scans, X-rays, and can refer you to pain management specialists as the case may require. So all these things are important because to build a personal injury case, we need to establish the two things. One is liability and one is damages. By the time that you've been to the doctor, the liability information should be set. You will have spoken to the police officers, you will have given your statements, and you can obtain a copy of the police report when it becomes ready. But now the next part of the investigation is really to track along with your medical treatment for the injuries. This is the damages portion of a personal injury case. So in the investigation, we spend a lot of time working with clients to determine what their injuries are, what types of medical treatment are required to help us assess the severity of an injury. In a motor vehicle accident case, you have to prove that your injuries are serious. This is because New York, as a public policy, has determined that every auto insurance policy should have something called no-fault insurance. No-fault insurance provides for $50,000 worth of medical treatment coverage and payments for lost wages for any accident case. However, the flip side of that coin is to bring a personal injury action against the other driver, you have to show that your injuries rise to that serious injury threshold. One of the ways to do that is to establish regular and consistent patterns of treatment, to follow the recommendations of your treating physicians. And oftentimes a course of treatment will escalate from what's considered a conservative course of treatment, meaning physical therapies, chiropractic, acupuncture type cares, into a more intermediate level, including pain management, whether by injection or by medication, and oftentimes to the most invasive form of treatment, which can be surgical intervention. Now, as far as the serious injury threshold is concerned, there are certain kinds of injuries that automatically qualify. Some of them are broken bones, loss of limbs, but the more common type, which we see a lot of in our practice, are the soft tissue injuries. So those don't fall neatly within one of the identified categories of serious injury. However, we can meet the serious injury definition if we can establish a consistent and regular course of treatment, and we can show that the injuries have caused what they call a serious and consequential limitation. So that's one of the things that the consistent course of treatment will help us establish. Now, once we've been through the investigation and we have a full understanding of the liability, who's responsible for causing the accident, and we have an understanding of what the injuries are, what types of treatments have been required, and what the nature and severity of your injuries are, then we get into the process of making a decision on whether or not to file a lawsuit. And there are several things that go into this decision. The first and most obvious is, are we able to show that the other driver is at fault? We look at the police report, we look at the accident photos, we look at the witness statements. The next is, do we think that we have an injury that qualifies as a serious injury as defined in the insurance law? So again, we look at medical records, we look at types of treatment, we look at the duration of treatment to help us evaluate the severity. But another important component of this is also understanding the different types of insurance coverage that there are. In New York, the minimum amount of insurance coverage for a driver who causes an accident is $25,000. Oftentimes, there will be policies that were just the minimum, so there's $25,000 of coverage available. So it's important to investigate what other types of insurance coverage there may be. Typically, the vehicle that caused the accident will be the primary coverage. There may be situations where there are excess coverages, meaning that the driver and the vehicle owner had different policies. Or there may be umbrella coverages, meaning that there was a policy that covered the driver or the vehicle beyond the initial coverage, the primary coverage. And then you also want to know what your insurance coverage would be. So every vehicle policy has what's called supplemental underinsured motorist coverage. What that means is, if I have an injury that's worth $100,000 and the person who rear-ended my vehicle has a policy that covers up to $25,000, I could collect that $25,000 from the individual who rear-ended me. And then I could submit a claim to my own insurance coverage for the additional $75,000 it would take to compensate me for my $100,000 injury. So understanding what the different types of coverages are that are available and how the interplay works helps us to evaluate whether or not to move forward with a personal injury litigation or whether we want to consider settlement. So in the case where I just mentioned that I had a $100,000 injury and there was a $25,000 policy, the choice is simple. Unless I get that full $25,000 from the person who's responsible, I'm going to have to move forward with the litigation. But what about the situation where I have a $100,000 injury and the person at fault has a $100,000 policy. It gets a little bit more complicated on whether or not to sue the case when they start offering, a settlement number that's $80,000 or $90,000. And part of the reason why an attorney is helpful is because we can help you understand the costs and benefits of moving forward with litigation versus taking a settlement that may not be the full value of your injuries. There are things to consider like time, costs of obtaining medical records, litigation costs, and costs of presenting expert witness testimonies, and of course, the risk and time that it takes to go to trial. So it's important to have an attorney who can help you realistically understand and navigate the investigation process so that we can get to this point where we're making a decision on whether or not the offer of settlement is worth accepting, or whether or not the chances are that you would do better moving forward with litigation and potentially proceeding to trial. If we do decide to move forward with a personal injury case, the first thing that happens is the filing of a summons and complaint. In New York, the statute of limitations to bring a personal injury action is 3 years from the date that the accident occurred. Now, the complaint is a document that gets filed with the court and explains in a general way what happened and why we think the other party is responsible for causing the accident. Once the complaint is filed, the law allows us a period of time to seek out and to serve the defendants with a copy of the complaint. That period of time is up to 120 days. Once the complaint has been filed and the defendant has been served, the defendant is then given up to 30 days to submit what's called an answer. An answer to the complaint is a general denial of certain portions of the complaint while acknowledging certain facts as being true, including their identities and that an accident may have occurred. They're going to generally deny that they were responsible for causing the accident. In the answer, the defendant also has the opportunity to give what are called affirmative defenses, or reasons for why they should not be held responsible for causing the accident. Once the answer has been filed by the defendants, we then begin a process of discovery. Now, discovery is the chance for each side to give to each other certain pieces of evidence that will be used to prove our case if we're the plaintiff, or to defend the case if you're the defendant. From the plaintiff's perspective, we want to make sure that we have gathered and have available to us all the documentation that would prove our liability. So that police report, any of the witness statements that we were able to obtain, any photographs from the scene of the accident, any estimates of repair for the vehicle, any out-of-pocket expenses that we might have incurred for our medical treatment, any of the surgical reports that we might have from any surgeries that were required. Things of this nature are going to be the evidence that help us prove, the liability as well as the damages. Now, from the defense standpoint, there may be certain affirmative defenses that they may have, and they would want to gather and obtain any of those types of documents or information or statements or photographs that they think would tend to help show why they're not responsible. Once the exchange of all that evidence and documentation and photographs and material has been exchanged among the parties, we then proceed into a next portion of the lawsuit, which would be the taking of oral testimony. Now, that's the opportunity for the plaintiff and the defendant to ask each other questions. Typically, the defendant has the first opportunity to take the deposition of the plaintiff. They get to ask the plaintiff all the questions about what they remember from how the accident happened, as well as all the injuries that they're claiming and what life has been like since the accident and since suffering these injuries. Now, the most important questions that can be asked during a plaintiff's deposition sound very similar, but are slightly different and really go to show the permanency and severity of the injury. The first is, are there things that you used to do before the accident that you can no longer do at all? And that includes things like working, recreation, family activities, things in your everyday life that you used to do on a regular basis that you either needed to do or that brought you joy or pleasure. If you can no longer do them all, those are permanent limitations. The second is, are there things that you used to do before the accident that you can not do as well as you used to do, or if you do them, they cause you pain or discomfort? Now, this is similar to that first question, but slightly different. And it also gives a inside view into what your injuries are like and why you claim them to be permanent and consequential. Now, oftentimes when I sit and I prepare a client for a deposition, I ask them these questions and they don't know how to answer that, because that's a question that they've never really thought about. They understand that they may have hurt their shoulder or their knee, or they might have, had a broken rib or a broken arm, but they haven't really thought about how that affects them in their everyday life. The last thing that you want to do as a plaintiff's attorney is to have your client in the deposition being asked those questions for the first time and having the client look at the defense attorney with a blank stare. I always ask my clients these two questions, and I don't expect them to answer it right away. In fact, I tell them that, let's think about this for a few days and come back and let's have another conversation about it. The reason to do that is it gives the injured plaintiff an opportunity to leave the conversation and then to go about their everyday life for a couple of days. And every time that they're bending over to grab something off the floor, or they're reaching to grab something out of a drawer, or they're carrying something in from the car, they start to notice, what are the things that cause me pain or discomfort when I do them? Or, what are the things that I might have been doing today if I wasn't, suffering from these injuries? Once they've had a chance to think about that, they can give a much more detailed and specific answer to those two questions. So I always work that into my preparation when it's time for depositions. Now, in the same respect, it's important to spend some time taking a good deposition of the defendant. We may think that the police report and the witness statements and the photographs tell the full story, but it's also important to understand what the defendant is going to say. And the deposition is the time to lock the defendant into his testimony that they might present at trial. If they're going to claim that the weather was a cause or condition that resulted in the accident, or if they couldn't see because it was raining or the roads were slippery, I want to know that so that we can figure out how we're going to address that. So the depositions are important so that you can lock the parties into their testimony if you're taking the defendant's deposition, or so you can get a better understanding and give context to the medical records if you're taking the deposition of the injured plaintiff. Now, after the depositions have been completed, one of the last steps in a personal injury case is the retention of experts. The experts are important because they are used to establish that serious injury threshold if you are on the plaintiff side or on the defense side. The defense usually likes an expert because what happens after experts is motion practice. A typical motion in a personal injury motor vehicle case made by the defense is called a threshold motion. They're going to argue to the court that your injuries do not meet that serious injury threshold. Their experts are going to say that if you were hurt, your limitations are not severe, and you don't neatly fall within one of the categories of the insurance law's definition of a serious injury, and for that reason alone, your case should be dismissed. On the plaintiff's side, you're going to want to have an expert who will do an evaluation and can talk and speak to the nature and severity of your injuries and the permanency and the limitations that your injuries have caused. So in that respect, the experts are a very important component to making sure that the personal injury cases survive the motion practice. Now, on the plaintiff's end, I like to spend some time doing motion practice on the liability side of the case. I like to ask the court to decide before we get to trial that the other driver or the other vehicle was responsible for causing the accident, and that my client did not cause or contribute to the happening of the accident in any way. The reason for motion practice is to help limit the issues at trial. And so I like to remove as many of the issues as I can for my clients. And I like to make those motions proactively so that when it comes time for trial, all we're really focusing on is the severity of the injuries and the damage it's caused and how these injuries have changed my client's life moving forward. So at this time, I'd be happy to answer any questions that anyone may have. And I'm going to see if there are any listed in the chat or the Q&A. Okay, I don't see any questions in the meantime, so I want to thank you all for attending, and I wish you all a wonderful afternoon. Thank you.